Yo, 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 it's your boy Jacob. How's it going? We're here with what is going to be video 6, our appellate brief and addendum. Here's the cover. A lot of the same stuff you would be used to by now from the other videos. Wearing my Snoopy U of M tee. Still got a 4.0 GPA at the U. I'm wearing one of the beanies I designed for one of my clients, Crested River. Instead of promoting apparel you can buy readily right now, ready to wear stuff, I want to promote my ability to design and manufacture custom apparel for you. So if you have an event, if you're an artist, if you're a brand, whatever, if you need giveaway items for your employees, hit me up. Slide into those DMs. Anyways, this video is for the most part really redundant. There's quite a bit of stuff to go through, but I'll try to sum it all up. It's nothing really new here. Here are the table of contents. You can pause and read this if you want. The noteworthy thing right here is the Albert Lea City Ordinance is first come, first serve. Even if respondents had not been obligated, the unexplained denial raises a prima facie case of arbitrariness. Respondent's denial of my application was arbitrary, capricious, unreasonable, or contrary to law under any other test. Conclusion. So this just kind of better sets out our arguments. Here are the case law references, statutes, city ordinances. It's fun stuff. Again, if you're in a position like this, you're going to want to have a good attorney that's versed with municipal/administrative law, and then whatever specific niche you're in, whether that's a school teacher getting a license, me getting a business registration, you're maybe like a construction or contractor working on another license, whatever. There's a bunch of applicable situations, probably an endless amount, since licensure and is a pretty universal experience for many industries. Anyways, the legal issue is whether the city of Albert Lea and the city council's denial of my application for registration was arbitrary, capricious, unreasonable, or contrary to law, since MnStat 342.22 requires issuance of registrations to businesses meeting limited objective criteria. In addition, the city council ordinances, the Albert Lea city ordinances passed by the city council, I should say, requires that respondents, the city, register cannabis businesses on a first come, first serve basis. Again, if we bring it back to video 1, you can't get more first come, first serve than being the first licensed micro business with a retail endorsement in the state and beating out all the local registrations applications by several weeks. You can read the rest of this if you want. I don't think I need to. It's kind of just setting up some criteria that we need to provide. And here is what we're referencing and providing. Statement of the case: the certiorari appeal arises out of a denial by the city of Albert Lea through the city council of a cannabis retail business registration. I applied for and received from the state of Minnesota the micro business license as required by law. They applied to the city of Albert Lea for a retail business registration. The city of Albert Lea's city council considered the application but denied it, though it did not set forth any reasons for its denial. This appeal follows. Statement of the facts. You've heard this several times. July 17th, I got my micro business license. On the same day, I applied for the registration pursuant to MnStat Chapter 342. That kind of mandates that we have to register with the city/local jurisdiction in which the retail establishment is located. And since I was in Albert Lea on that same day, again, we did the application with the city. This part's a little different that you probably haven't heard before, but still on July 17th, 2025, Albert Lea City's clerk, Daphne Morris, who I think is a really great person, certified that realtors had paid the appropriate fees, are current in all applicable tax obligations, and had passed a preliminary compliance review and were authorized to engage in retail cannabis sales in the jurisdiction named above. That certification was false insofar as it purported to grant realtors their cannabis business registration, despite purporting to allow realtors to engage in retail cannabis sales. Albert Lea City Ordinances 5.023 required that a complete application was to be forwarded to the City Council for approval or denial. In keeping with the ordinance, the application came before the City Council on July 28th, first at its pre-meeting work session, and then at its regular meeting. At both meetings, respondents expressed a clear understanding that they were not empowered to deny realtors' application. At the City Council's work session, City Manager Patrick Ian Rigg first said that some of the questions have come up about, can we pick and choose who we'd like because of certain past action items? Mr. Rigg continued to state that the simple answer is, well, no, the state has not given us that authority. You're not even responsible enough to have that authority, clearly. Mr. Rigg went on to acknowledge that Albert Lea's city ordinance was written to minimize its risk, which is first come, first serve after the OCM has done their work. At the regular meeting, Patrick Ian Rigg averred that Albert Lea had determined that the only objective way to limit the number of registrations to 2 was to create a first come, first serve basis about who completed the process with the OCM first, paid their registration, and then we received time dated and time stamped. We received them as being first and second for those two spots. This fucker can't even spit out a coherent sentence without stuttering and stammering. You should not be our city manager if you can't give an eloquent and concise response while you're at a public recorded meeting, period. Do you not practice anything you say? Are you not practicing any of this with like a friend, a partner, or even the other city staff? Come on, I expect better. My tax revenue is going to that. I want better. That's all I'm gonna say. If you're someone who lives in the area, run against these fuckers. This is one of the easiest things to use against them all and show how incompetent they are. Again, I say that with nothing but respect to them as human beings, but nothing but embarrassment as a citizen of the city. This is embarrassing for all of us. Members of the Albert Lea City Council opposed the application, but for reasons having nothing to do with relators' application itself. Councilmember Baker stated that, I get tired of control being taken by whether it's state or federal government in things that they know nothing about. And so I'm not for this. It has nothing to do with who, what, or where, in my opinion, from my decision. But I'm not going to support this just for this simple reason. I don't believe in the fact that as local people who are involved in this, we know what's best for us, that we get that taken away from us. Bro, the law passed years ago, legalizing cannabis. You knew this was coming. You all passed the ordinances unanimously. And now in the 11th hour, you're trying to bitch and moan like a little child who had their toy taken away because they got told to do homework or do their chores. Focus on your fucking job, you clown. That's it. Councilmember Rachel Christensen said that, I also don't want to support this because I've had so many comments from my constituents saying no. Okay, you can say that, but then you still have to do your job as written in the ordinances you voted on, as written in the state law that very clearly mandates you need to give me my registration. If you can't do your job as an elected official, you should immediately resign and make way for someone who will do your job and not bring shame upon our entire city. The good old Mayor Rich Murray expressed that, I have not been a fan of this since the subject first came up a year ago. It seems like just 2 years ago, we were locking people up for this very thing, smoking cannabis. And now we're promoting it? I do not like the way that the state legislator and the governors ram this down our throats. Oh, I bet you love things rammed down your throat, Rich Murray, without very little say in the whole process. All because they're hungry for more revenue? In my one video, you saw me making gestures like it looked like Mayor Rich Murray was getting shit rammed down his throat. Again, my memory's a little foggy. I believe those gestures were made because he was physically kind of reenacting what it might look like for something to be rammed down his throat, since he's probably used to it, in my opinion. So not a fan. I don't think 2 is the right number, as I've said before. I believe 0 is the right number. I'm just not a fan of this whole deal. Oh! And then I believe, maybe my memory's fuzzy, he burst out into tears. I don't know. Again, I am a little deaf, so if my recreation of the events and their statements doesn't sound accurate to who these people actually sound like in real life, it's probably just because I'm deaf and I was having a hard time hearing with their mouths being full of bullshit while they were speaking. So I apologize, I don't mean to be disrespectful. Weak human beings that have no spine, that's how they sound to me. It's just my subjective interpretation of the events. And frankly, maybe we should be holding up a mirror to these clowns of a city council. I think so. I mean, seriously, think about it. Who cares what you think? Your opinions are completely, utterly, wholly irrelevant. You're there to follow the law, the state law, and the very ordinances, city laws that you all passed unanimously. Now in the 11th hour, you want to cry that, maybe we should have thought this through more? Well, too little, too late. And years after the state laws are passed, when you had ample time to do something about it and make your grievances known to the state, to the legislature, and to the OCM, only now, after years have passed, you're going to take a stand? If I didn't know any better, I would say you guys discriminated against me, and that might be a whole different lawsuit. But hey, we'll see. I might have to look into that. It's just my feelings. Continuing on, Mayor Murray and council members Larry Baker, Rachel Christensen, and Keith Van Beek, who did not speak, all voted against approval of the application, and approval of the application failed by a vote of 4-3. To the 3 of you that voted for this, y'all goated, bro. I love y'all. Other than their disagreement with what Minnesota law and their own ordinance require, respondents have never identified orally or in writing a basis for denying my application. I timely applied for the writ of certiorari. The writ issued, and it was timely served upon the city of Albert Lea and city council. Argument. In 2023, Minnesota legalized adult use of cannabis. I literally have a signed celebratory HF 100 bill by Governor Walz. I stood next to him when he signed it at the ceremonial signing. So yes, in 2023, we legalized it, adopted Chapter 342 of the Minnesota statutes, and Chapter 342 sets out a comprehensive framework for the regulation of cannabis in Minnesota. Much of the responsibility for cannabis regulation falls on OCM. MnStat 342.02, OCM is responsible for issuing cannabis licenses. 342.02 also states that before making retail sales to customers or patients, a cannabis business must register with the local jurisdiction in which the retail establishment is located. State law provides for a level of local control over cannabis businesses. 342.13, state law also provides, however, that a local unit of government shall issue a retail registration to a cannabis business that meets a certain set of limited requirements. Shall is mandatory. Chapter 5 of the Albert Lea City Ordinances regulates cannabis to approximately the greatest extent that state law allows the municipality to do so. Again, getting a little redundant. I know you've heard this before. Stick with me. The chapter, which is expressly based in part on state law authorizing local government units to adopt zoning ordinances, Albert Lea City Ordinances 5.002 creates a registration and application procedure with 5.023 creating an exclusive list of reasons the city may deny or revoke the registration. 5.029 provides that the city of Albert Lea will register cannabis businesses on a first-come, first-served basis, which will be based solely on a time-stamped, state-issued license. Emphasis added. Shout out to you, David. I love the work you do. For now. In denying Relator's application, respondents have put politics above the law. Something the law does not allow. Yeah, no shit. This court should reverse respondents' decision to deny my application and remand the application to respondents with instructions that they grant the application. 1. Respondents' denial of my application was arbitrary, capricious, unreasonable, or contrary to law, or all above. Minnesota statutes require a local unit of government to issue a cannabis retail business registration to one that meets all the objective requirements. Furthermore, the city and city council themselves chose to enshrine in their own ordinances a system requiring them to grant a cannabis retail business registration to the first qualified applicants, period. Respondents' decision to ignore the clear command of not only state statute but their own ordinance is, by definition, arbitrary, capricious, unreasonable, or contrary to law. Even if respondents had some discretion, however, they failed to record any valid reasons to deny the application, and indeed had no such reasons, this court should reverse and demand. And if we back it up again, they enshrined in their own ordinances the first come, first serve method, which essentially removed all of their discretion, which already, for the most part, didn't exist due to state law. Standard of review: when a statutory right to review municipal bodies' quasi-judicial decision is lacking, certiorari is the exclusive method to seek judicial review. A municipality's decision is quasi-judicial if it involves 1. Investigation into a disputed claim and weighing of evidentiary facts, 2. Application of those facts to a prescribed standard, and 3. A binding decision regarding the disputed claim. Certiorari review is limited to questions of jurisdiction, regularity of proceedings, and whether the decision was arbitrary, oppressive, unreasonable, fraudulent, under an erroneous theory of law, or without any supporting evidence. Excuse me. The party seeking reversal has the burden of demonstrating error, which I think, just my opinion, I'm not a lawyer, is a little bullshit, just because a citizen shouldn't be burdened with more nonsense to fight what is otherwise an oppressive and tyrannical, fraudulent, erroneous, arbitrary, etc., government. In other instances, though, where you're maybe not going up against a government, I could see where that makes sense. Just maybe more clarification could be added, because the government is very much a powerhouse and the average citizen should not be burdened, especially when it's our taxes going to funding the very government in limited situations like this. Obviously, not every situation where a writ of cert is used is against a quasi-judicial body or otherwise the government. So, courts conduct limited and deferential review of a quasi-judicial decision, a standard which is rooted in separation of powers principle. But the interpretation of a statute is a question of law that courts review de novo. 2. Minnesota law sets out an exclusive list of reasons a municipality may deny a cannabis retail business registration. Under Minnesota's cannabis regulation framework, much of the responsibility for regulatory functions falls upon OCM MnStat 342.02 Subdivision 2. The licenses OCM issues are the primary regulatory approval for cannabis businesses. MnStat 342.14 is referenced here. For example, MnStat 342.14 requires that a complete application for a cannabis license must include more than a dozen pieces of information, including such details as a description of any training and education that the applicant will provide to employees of the business, and may deny any application for any 9 reasons. I remember my final walkthrough with the state, and even in the first one, they made it clear that my procedures, SOPs, training manuals, and all that were very thorough. Their words, not mine. And we even joked repeatedly about how employees might be intimidated for to work for me because of how thorough everything was. But yeah, I think they did a great job at a lot of this, so I'm not going to bring any negativity towards the OCM. However, before making retail sales to customers or patients, many cannabis businesses must register with the city, town, or county in which the establishment is located. Yep, 342.22, that registration is the last step in the approval process. 342.22 again goes on to say that a local unit of government shall issue a retail registration to a cannabis business within defined classes that 1, has a valid license, 2, has paid the registration fee, 3, is found to be in compliance with requirements of this chapter, 4, is applicable and current on all property taxes and assessments at the location where the establishment is located. MnStat 342.22 is what laid all that out. Again, shall is mandatory. MnStat 645.44 Subdivision 16. Thus, the legislature did not intend, nor does Minnesota law allow the local units of government to be able to deny a retail registrations for reasons other than those the legislature enumerated. Oh, where's your discretion there? It doesn't exist. Other provisions of MnStat Chapter 342 support this conclusion. For example, while MnStat 342.13 allows local governments to limit the number of cannabis retailers based on the locality's population, MnStat 342.13 goes on to say that if a county has 1 active registration for every 12,500 residents, a city or town within the county is not obligated to register a cannabis business. Emphasis added. And this is a really good thing for anyone in this exact position to know about. So listen to this. That provision implies the converse, that if a county does not have that many active registrations, a locality is obligated to register a cannabis business. Obligate means to bind by legal or moral duty, to make someone have to do something because it is the law or has become that person's duty. Obligate, Black's Law Dictionary. Shout out Black's Law Dictionary. If you don't know, well, I'd recommend buying one if you're in these types of situations frequently. The use of mandatory term obligated also further clarifies that the reasons for refusing to issue a registration enumerated in MnStat Chapter 342 are exclusive, not a starting point to be added to by the whim of a local unit of government. Need some water. If you haven't, drink some water today, folks. 3, Albert Lea's ordinance requires that cannabis businesses be registered on a first come, first serve basis. Long before relators applied for their cannabis business registration, respondents gave a great deal of thought to the structure of their cannabis business ordinances, by a couple of years actually. Patrick Ian Rigg asserted that Albert Lea's ordinance was written to minimize the city's risk, which is first come, first serve after the OCM has done their work. Indeed, Albert Lea's city ordinances 5.030 provides that the city of Albert Lea will register cannabis businesses on a first come, first serve basis, which will be based solely on a time-stamped state of Minnesota OCM issued license. Emphasis added. The record indicates that my application was the only application that the Albert Lea City Council considered at its July 28, 2025 meeting, and it indicates that the applications the city of Albert Lea and the city council granted on August 11th were based on licenses issued on July 24th and July 29th of 2025, respectively, and registration applications to the city of Albert Lea filed on July 24th and July 30th of 2025, respectively, both of which post-date my July 17th license and registration application. Based on their own ordinance, respondents were obligated to grant relators' application for a registration, but they did not do so. 4. Even if respondents had not been obligated to grant the registration application, respondents' unexplained denial of my application raises a prima facie case of arbitrariness. Excuse me. A failure of a city council to record any legally sufficient basis for its determination at the time it acted gives rise to a prima facie showing of arbitrariness, a presumption that the governing body's decision was arbitrary. Courts in this state have repeatedly applied and granted relief based, at least in part, on this doctrine. And then they kind of go into some case law stuff. Affirming district court ordered the city to issue a special use permit where the city kept no record of its hearings, made no findings of fact, and recorded no reasons for its denial of permit. See also Hans, City of Coon Rapids, setting out procedure for judicial review of municipal zoning decisions and noting that municipalities must record their reasons or risk judicial reversal of their decisions. Holasek v. Ville of Medina, affirming a district court order requiring issuance of a special use permit where village failed to make a record of facts or reasons for denying a permit application. Inland Const Co. v. City of Bloomington, reversing district court's affirmance of city council action denying a conditional use permit and finding that the trial court erred in sustaining the council's denying of the conditional use permit when the city court based its finding on reasons not articulated by the council. We got City of Barnum versus Carlton County, reaffirming reversal of district court's affirmance of county's decision to deny a conditional use permit where a record could not support any findings that the county board might make on remand, and that the prima facie showing of arbitrariness was therefore unrebutted by the county. Curtis Oil versus City of N Branch, finding it impossible to determine whether there was a rational basis for a rezoning application denial where no reasons for the denial were included in the council's minutes, and determining that the city chose to run the risk of not having its decision sustained. We got N States Power Co. versus Minnesota Department of Transportation, reversing a decision made by the state administration agency action. Respondents are subject to well-established statutory and judicial requirements to explain their decisions in the zoning arena. MnStat 15.99 sets out various procedural requirements for zoning-related requests to government agencies, and among these is a requirement that when a multi-member governing body, such as the Albert Lea City Council, denies a request covered by the statute, it must state the reasons for denial on the record and provide the applicant in writing a statement for the reasons of denial. And they did not do that. I was never given any denial, at least in writing. Just that bullshit inflammatory city council meeting. Both of them, I should say. Similarly, case law requires that a zoning authority must record legally sufficient reasons for the denial of a zoning request that are factually supported in the record. The Albert Lea City Council did not meet those obligations. The record does not contain any statement whatsoever, oral or written, by respondents that explains in any way the Albert Lea City Council's reasoning for its decision. In failing to, at a minimum, have the reasons for the City Council's decision recorded or reduced to writing, and in more than just a conclusory fashion, the Albert Lea City Council ran the risk of not having its decision sustained. Indeed, in similar such cases, an agency's failure to record any legally sufficient basis for its determination at the time it acted made a prima facie showing of arbitrariness inevitable. emphasis added. When such a showing is made, it is rarely overcome, and if the zoning authority's decision is arbitrary and capricious, the standard remedy is that the court orders the permit to be issued. 5. Respondent's denial of my application was arbitrary, capricious, unreasonable, or contrary to law under any other test. Reading a bunch makes me yawn so much. I'm so sorry. Minnesota law is unambiguous that an agency must either follow its own regulations or amend them in accordance with statutory rulemaking procedures. I'll just read the case law. See also Hamlin Midway Neighborhood Stability Coalition, I'm guessing, versus City of St. Paul, reversing city's issuance of a license for failure to follow requirements for issuing the license. Yep. In addition, the Minnesota Supreme Court has held that, it is now settled that where a zoning ordinance specifies standards to apply in determining whether to grant a special use permit, and the applicant fully complies with the specified standards, a denial of the permit is arbitrary as a matter of law. Albert Lea's city clerk, shout out Daphne, found that I had met the standards set out in Albert Lea city ordinances, indeed going so far as to certify that I had paid the appropriate fees, were current in all applicable tax obligations, and had passed a preliminary compliance review, and were authorized to engage in retail cannabis sales in Albert Lea. And by the way, AR stands for Administrative Record. When an agency significantly deviates from reviewing authorities' conclusions, it must explain the deviation, and the failure to do so evidences the agency's desire to exercise its will and not its judgment. That certification, together with the objective selection criteria in Albert Lea City Ordinances 5.030 that respondents refused to follow, shows that I met the City of Albert Lea's criteria for cannabis business registrations. Moreover, respondents knew that they were required by both Minnesota statute and their own ordinances to issue a cannabis retail business registration to the first qualified applicant, and it should not be lost on the court that their city and city council knew that they had no grounds whatsoever to deny my application. And this is a big juicy quote here. Patrick Ian Rigg, the city manager, described respondents' role, the city and the city council's role, in granting or denying a cannabis retail business registration as officially a big rubber stamp. Patrick Ian Rigg even understood that denying the application would be so baseless that if there were litigation, he doubted our insurance would even cover it, because if we were to take a negative action that resulted in us not following our own ordinance, not only not following our own ordinance, I don't even think our own insurance company would cover us. Bruh. What the fuck? Y'all a joke. Yet this Albert Lea City Council did just that. Let's pause this. Feel free to screenshot this one. Feel free to post it everywhere. Conclusion: respondents have purported to put themselves above Minnesota law, have arrogated for themselves the ability to violate their own ordinance, and even if they had not, their decision would still be arbitrary, capricious, or contrary to law. This court should reverse the city and city council's decision to deny my application and remand the matter to them, the city, to grant the application and issue the cannabis retail business registration. Signatures, that's it. This is the juiciest thing here. Well, a lot of it's pretty juicy, let's be honest. There's not much else to say. The case law that was referenced hopefully could help other people and maybe save their own attorney some time in finding the relevant case laws for their matter, thus saving you some money. I don't know, possibly, hopefully. I do find it funny that Rigg reversed his own wording and contradicted himself, stating it is not clear we are not compelled to be a rubber stamp. Yeah, bullshit. It literally says you shall give me my registration in the state laws, and your own ordinance says first come, first serve. Additionally, your own city clerk told me over the phone before the July 28th city council hearing that I shouldn't have to worry about anything because it's just a formality, the city council voting on things. That's a formality, that their job is to basically rubber stamp things that have already been approved by the city staff, like herself, the city clerk. So again, you really are, in my opinion, just a big rubber stamp, and you have a job to do. You're paid by the taxpayers of Albert Lea to do that job, and failure to do that job, especially if it's this egregious, in my opinion, should end in only one way: your incarceration and permanent barring from holding any other elected office in the nation, period. We need to put people like Patrick Ian Rigg, Keith Van Beek, Rachel Christensen, and Larry Baker, and Mayor Rich Murray on a list that is publicly available nationwide that shows that they violated their own laws and state laws while holding office. People need to know this. It is for the public's best interest and safety that we compile this nationwide and make sure it is easily findable and accessible by every citizen of this great nation. We are for the people, by the people. And if you do something in your official capacity against the people, against your very own constituents, that especially violates a law, especially laws that you've voted on and passed yourself, that you be noted as, in my opinion, a dictator, a tyrant, a despot, a wannabe king. That's really all I got to say today, folks. Hopefully this helps. Thanks for watching. Like, share, and sub. Peace.